You have 15 minutes. Would you like to reserve some time in rebuttal?
I would like to reserve 5 minutes, please.
5 minutes. So what I'll do, obviously, because we don't have the podium, if you can just kind of keep track of your time, but when you get close, I'll just let you know that you're getting close. Okay? All right,
great.
when you're ready.
Okay. I'm sure the court is well aware of Mr. Ingalls. He has been to the First District on a number of occasions. Most recently, there was a resentence that took place after a remand from this court back in 2018, which, as I understand the decision, the point of the resentencing was to remove the life tail because that was not pursuant to the statute back in 1998 when he was sentenced. That was the offending.
Romero, is there anything specific you would point to in that decision that says what you just said? In other words, just remove the life tail. That's all the trial court has discretion to do.
Yes. So I'm looking at page 8 of that decision. And basically the court is saying that the statute at that time did not confer upon the trial court the authority to enhance his sentences for kidnapping as charged. As a result, those sentences are void and subject to correction by the common pleas court. So again, I read that, the court did not have the ability to enhance, and the enhancement at that time was to add on the life tail. And that was the offending portion of that sentence that should have been removed. So our argument is, well, my client did want me to argue, and I think there's some merit to that the sentences were done back in 2016 if you take off the offending portion. I think that was even confirmed by the Ohio Department of Corrections, and I think maybe even an email from the prosecutor's office. That was their understanding. So if that's the case and his sentence expired, then there was nothing to actually correct because he should be released. But even if the court doesn't believe that to be the case, according to that directive, it was the life tail that needed to be removed. And when Judge Shanahan increased his sentences, and I actually caught an additional enhancement, I guess that might be a bad word, but so not only did she increase the sentences on counts 1 and 2 from 9 years to 10 years, she also made the sentence in count 2 consecutive, where in all the prior sentencing entries, count 2 had been concurrent by all the.
When you say increase the sentence, the overall sentence is lower under Judge Shanahan's sentence than under the prior one, is it not?
It is. I mean, especially if you take away the life tail, certainly. But I think the Supreme Court has been very clear that we don't look at the entire sentence when we're looking at whether there was vindictive sentencing under Pierce. We look at it on a count by count basis. And if that's the case, and if we're looking at just the one count, she increased that count from 9 years to 10 years. And I do believe there is a presumption of vindictiveness under Pierce because she was the sentencing judge who put in place the 9 years to life. And I don't think that has been overcome. I did not see anything in the record to suggest that she looked at anything that has happened since her last sentence that would warrant her to increase that sentence, other than to merely punish my client because he's getting the benefit of losing the life tail. And as I said, she not only increased the sentences on 1 and 3, she then made count 2 consecutive, where historically it's been concurrent. It's not a significant amount of time. It was only 18 months. But it still shows, in my opinion, that was vindictive and improper.
Are you familiar with State v. Harper from the Ohio Supreme Court recent decision?
I am. I did have the opportunity to review that, and I don't know that applies in this particular case. And the reason I say that is this court had already determined that the sentence was void, went back for resentencing. We're now on appeal, not necessarily on the void argument, but whether the court properly followed the Court of Appeals directive. Although I would certainly argue that if the court imposed a sentence improperly and was incorrectly applied, I do think it could be considered void anyway. But I don't think that's the argument that we're making in this case today.
Right. Well, I mean, I guess that's the problem under Harper. If you say it's a void sentence because it's improper, I don't know that makes sense under the world that Harper has decided now.
I guess the way I would look at it is when she made the ruling that she did. So it was determined to be void in 2018, went back, there was a resentencing, and she imposed a sentence. I'm not saying that the sentence is now void. My argument is the sentence she imposed was vindictive and she should not have done it. The only thing she should have done is to remove the life tails on 1 and 3 and otherwise kept the sentence the same. So that would be 9 years on counts 1 and 3. Count 2 would still be concurrent under the old sentencing that she imposed. And then count 8 would be 4 years. So that's what we're asking.
Other than the sentence being lengthened, what evidence is in the record to show vindictiveness on behalf of the trial court?
Well, again, I think under Pierce, we have a presumption of vindictiveness because it's the same sentencing judge. So I don't believe the burden is on us to show vindictiveness because that presumption applies. I don't believe there was anything in the record to suggest why she would have increased the sentence. She didn't point to any objective facts as to why the sentence should be increased at this point, because she relied on the same facts she did when she sentenced in previous years, or even when it was imposed back in front of Judge Crush. So I think because of the presumption that was not overcome, that it is, again, presumed to be vindictive. The other issue that I raised concerns the sexual predator classification. And I made the argument as well that if the sentence had been done back in 2016, that obviously we can't classify at this point because his sentence has been done. Otherwise, my argument is that the court did not look at all the factors under Eppinger properly, and it made that decision improperly despite the evidence from Dr. Nichting. We have a gentleman who is in his 70s, not doing well health-wise. To impose a sexual predator classification, it did not make sense under the different factors that were required to be found. So we're asking that the court set aside that and make just a designation of sexually oriented offense. And that's all I have for now. And if there's any other questions.
Thank you, counsel.
Ms.
Adams.
Good morning, Your Honors. Ms. Stagnaro. With regard to the first assignment of error, I think that the trial court statements on in the transcript, pages 23 to 25, indicate that the judge was not being vindictive. She was interpreting the remand order from this court, and certainly this is a case really of first impression. When we have the original sentence, the judge had the option of a large span, including a life tail. And on remand for that life tail aspect to have been removed, it was certainly within the trial court's discretion when then being ordered to resentence the defendant, just as the trial court had indicated, and certainly opened it up for that 3 to 10 year sentence. We have the original sentence, the judge had the option of a large span, including a...
It's coming off of Abby's.
Remand for that tail aspect to have been removed, it was certainly within the trial court's discretion when then being ordered to resentence the defendant, just as the trial court had indicated.
If everyone mute their lines, I see there's a lot of people on that have not muted.
Abby should mute.
Yeah.
Oh, sorry.
Okay. All right. Sorry, Ms. Adams.
I heard that 3 times.
Just another sign of the times. All right. Thank you. You may continue.
Okay. So certainly I think that the idea that this was vindictive when essentially, the trial court was just using its discretion with a much more limited span pursuant to the remand. So I don't think that there's any merit at all to the fact that the trial court imposed the sentence that it did. Now, with regard to the Megan's Law sexual predator finding, I've been doing this for a long time, and this individual is the textbook sexual predator. I mean, this law was designed for an individual like this. We know of 9 victims of his, and this was, individuals that he brought into his home under the guise of conducting job interviews for his home business that he ran, and drugged them and had sexual intercourse with them. I can't think of another scenario where this law would be applicable. And the judge had multiple sources of information, psychological reports regarding this individual, as well as the facts of all of his offenses. And, certainly what he's done with his time while incarcerated. So I don't think that there's any abuse of discretion whatsoever with regard to the trial court's finding. And, once that life tail, that specification, because he was automatically classified as a sexual predator so long as he had that specification conviction. So then when the trial court used its discretion for that classification, all of that information was suitable for the court to consider. And I don't think there was an abuse of discretion.
So do you see any impact of State v. Harper on this appeal?
Well, I think now it's clear that the void versus voidable issue, but I don't think for, as I believe you indicated before, that's really necessarily applicable with regard to the resentencing that Judge Shanahan did for the purposes of this appeal. Unless there's any further questions, okay, I'm going to mute now.
All right. Thank you, counsel. Ms. Stagnaro?
I don't have anything further to add unless there's any additional questions for me.
All right. Do we have any questions?
I don't.
All right. Thank you very much for your arguments this morning. The case is now submitted. We will review the record and issue a timely decision. Thank you.
Thank you all.
All right. Keith, do we have everyone on for the next case?
Yeah, everybody's on, Judge. We're ready to go for the second case.
All right. Then back on the record, this is In Re C, G, and H children, C20-0215-217. Good morning, counsel.
Good morning, Your Honors.
Good morning, Your Honor.
All right. So we have Mr. Capsule, Mr. Inglesamo, Mr. Harden, and Mr. Bisignano. Is that correct?
That's correct, Your Honor. I would like to start with an apology. We had a COVID test come in over the weekend, so I'm working from home. That's why you can't see me. My home computer does not have a webcam.
All right. Well, I hope everyone is doing as well as possible. So we have Mr. Capsule is representing the mother, the appellant, and then also Mr. Eglezamo is representing Ms. Hayes. I assume both of you intend on arguing this morning and would like your 15 minutes. Would either one of you like to reserve? Well, first of all, who would like to go first, just so I'm keeping track here?
We had discussed it, Your Honor, and that what we do, reserve 3 minutes, and then it leaves us 12, so I'll do the first half, and then Mr. Anselmo will follow up.
Okay. All right. Well, then when you're ready, sir.
All right, thank you. If it please the court and counsel, just by way of context, I've been representing this mother for 5.5 years now. But our argument essentially is weight and sufficiency with regards to mom, and also with Ms. Hayes' petition. I don't know, Mr. Anselmo's brief talks about it, does an abuse of discretion analysis with regards to the Hayes position. Remedy-wise, what we would ask is if one of two things, that mom can get her kids back, or that the two boys, DG and DC, go to Ms. Hayes, and then the DH goes to mom. It's interesting to note in the history of this case that JFS and the guardian ad litem almost had the right outcome in the history of this case, because there was a motion to remand custody to mother filed at the end of September, at the end of 2017. And also later on in the case, even after that was filed, the agency and guardian ad litem both put on the record that they had supported the petitioner, Ms. Hayes, in her pursuit of at least the two boys, because of course she did get custody during this of another child of mother's. If you're looking at the history of the case, as far as the facts go, the agency's motion filed in 2017 says that they were satisfied with mother's participation in case plan services. Really not a lot had changed since then, other than their approach, attitude about what they were pursuing. Mom did have some misdemeanor charges pending, but there's no evidence that she had spent any time during this case or during the trial time locked up for any particular period of time.
Well, but the crux of it seems to be the domestic violence and the ongoing issues with respect to her inability to extricate herself from that relationship.
I don't know that in the history of this case there was really any domestic violence involved. There was, because we were in protective supervision for so long. And then I know the guardian ad litem brought in a bunch of police runs about domestic disturbances and she had with her then paramour. Later on, then that was, I guess, in 2016. Then there was one during the trial, evidence of one call that mother had made that wasn't domestic violence either. So I don't know that we could really fairly say that she could extricate herself from domestic violence relationships. And I don't know that
Mr. Capsule, what about the lack of, she didn't have stable housing, she had a number of evictions, and then she had no ability to provide for the children because she had no income. What do you say about those factors that the court considered?
Because we'd been involved with this so long that there was a history over time of her ability to get housing. It wasn't the whole time that she was without housing. There was a period of time where she had lived with Ms. Hayes. There was a period of time then when she was on her own. Because she was a young mother when this started, she had gone through Lighthouse Youth Services, and there was testimony in the trial about her work with the mental health and the housing people there. So she had the ability to obtain housing, in the milieu, the poverty and other issues that people face sometimes impact that. But we were in protective supervision for a long time, so I don't know that that was a constant issue. It just happened to be an issue during the case. And sometimes when your children are removed, that just exacerbates your problem in terms of what you're able to do in terms of housing. With regards to and that kind of leads into the facts about the other services that mom didn't get involved with it. With regards to the agency, I mean, even when they filed in 2017, there wasn't a concern with housing then. She did use the services in terms of doing the diagnostic assessment and the mental health services, and we did put into evidence her Peach Acres parenting certificate, and I think the testimony from the FNC visit facilitator was very compelling in terms of the bond with each other. So that puts into effect, first of all, whether or not what the record shows, and then I think it's worthwhile looking at how the trial court at least handled, because one of the children was less than 12 of 22 at the time of the filing, that implicates one of the 414Es, 1 through 16 factors have to be found. I don't know that the trial.
I'm sorry, Mr. Capsule. Was that the child that had been in custody since birth? Is that DH, the only one that wasn't 12 or 22?
DC, yes.
DC. Okay. Thank you.
So as far now, also on my manifest weight and sufficiency evidence on Ms. Hayes, first of all, nobody's really argued it, but I do think that based on the case law that we have standing to argue this on behalf of my client and her parental rights, because she was pursuing them, and of course Ms. Hayes did appeal. What most significantly with this case is the end result is that you have, well, mom had 5 kids, and during the course of this, 2 of them went legal custody to, one to Ms. Hayes actually, and one to another grandmother. And so it leaves these 3. that Ms. Hayes asked for 2 of them. So we end up with a lot of different households and no reason to have 2 of them just permanently separated from the rest of their family and a group of people that really love them. With regards to Ms. Hayes and the weight and sufficiency, it appears from the record that the only thing that the agency really had an argument with is the money aspect of it. So that would make it really not clear and convincing evidence that Ms. Hayes was unsuitable.
Well, Mr. Capsule, isn't there evidence in the record that she hadn't completed the required background check as part of the investigation? And also there was testimony that she really had not regularly visited with DC and DG.
Well, I think that the evidence in the record is kind of overwhelming in the other direction. Ms. Hayes was literally there on what we call the day 1 of the case. Back in September of 2014, when it was in protective supervision status. She came consistently throughout the court case. And I know that the guardian ad litem consistently bring up the Schaefer case. And I think the Schaefer case here really guides the analysis in favor of Ms. Hayes, because in that case, we talked about some grandparents that had only recent contact that lived off in West Virginia and maybe visited once a month. You contrast that with Ms. Hayes, that she was there at the beginning of the case, that she had the children living with her. That's overwhelming, that they had bonded with her. Ms. Hayes was the respite provider for the foster care network. Her daughter who lived nearby, became the foster parent for 1 year and 3 months of these children's lives. All of the children had, all of the children had lived with Ms. Hayes, all of them, except the one that wasn't part of this case, the youngest daughter. So all of the children in this case lived with Ms. Hayes.
Mr. Capsule, I think one of the court's concerns was that Ms. Hayes' plan for babysitting, given her situation as well as her husband, was to have the mother act as the babysitter. I think that's in the record. Am I correct in that?
I think, Your Honor, that was the significance of why we reopened the case. First of all, there's some discussion, and it's kind of having your cake and eating it too, in a sense. The agency found her completely suitable to have custody with no concerns about daycare or husbands or anything else with regards to Luru, the oldest, that child. But with regards to the other ones, well, now there's suddenly concerns. But we reopened the case because we believed that the agency had just approved her homestay, which they had originally, for all of the kids. And then there was this discussion, but we reopened the case, and Ms. Hayes came in at the reopened hearing and explained, first of all, what's with regards to the financial aspects of daycare. Now the kids are older, so they're in school. Whatever concerns there had been originally when they were not in school, I think the youngest child, DC, was maybe preschool age. But when she came back, she had a plan. That was the agency's concern, but then the agency's investigation was calling her while she was on her way home in the car, and then not really following up on it. But we had reopened the hearing. She was able to explain very thoroughly about how she had the dependent care flexible spending account through the federal government where she works, and how she had identified local daycare. She also had her daughter, who was the former foster parent, now living with her. They were living together. So all of these issues about daycare and all that, there was a concern, you're right, but it was a misplaced concern because it was really handled by Ms. Hayes. I think that also the other point about the Schaefer decision is that the Schaefer decision talks about the 11th district, I think, saying that the legally secure placement, the 414 D1D factor, was overemphasized in that decision. But I think that the court overemphasizes wrongly the D1A decision or factor to say that, well, these 2 children had been with these foster parents. Well, first of all, I don't know that we can hold that against these children and keep them away from their natural family just because from the time of the filing until the time of the trial itself was 2 years, the initial filing being in 2017. It was 2 years just to do the trial part, and for different reasons. But ultimately, it would overemphasize the fact that these 2 children have been with these foster parents and bonded for some period of time. You can't overemphasize that factor over the bonding relationship that they have with their parents and the lifelong history with mother and Miss Hayes. So no other questions. I'll yield the balance of my time.
All right, thank you, counsel. Counsel for the appellee, JFS.
Yes, Your Honor.
Judge Mock, I thought the other appellant was going to argue.
I'm sorry, I couldn't hear. So, Mr. Capsule, you were reserving some time, and then I'm sorry.
I was yielding the balance to Mr. Anselmo.
Okay.
I wasn't clear. Sorry.
All right. Well, it's fine. Mr. Anselmo, would you like to go ahead and argue now, then, sir?
Sure, Your Honor. How much time do I have?
You have about 8 minutes.
Oh, okay.
Oh, and then, but he said reserve. It's fine. We're doing the best we can. So, how much time do you think that you need? Let's go with that.
Yeah, my guess is I won't use all 8 minutes.
Okay.
I think Mr. Capsule had pretty much encapsulated a lot of the argument that I bring to the table from Ms. Hayes. I guess.
Well, and I guess I wanted to build on that and ask you some of the questions that I was thinking about with respect to his argument, which is, I mean, I think there is a disconnect between granting her custody over the elder child and then saying she's not suitable for the other children, but it is an abuse of discretion standard for this. So maybe if you could talk about that issue to start.
Yes, Your Honor. Right, we are dealing with an abuse of discretion, so it is a heightened standard in that situation. But I think if you look at not only the fact that you have the parties agreeing and the court eventually providing the custody to the oldest child, LaRue. But if you look back also, and I think this was mentioned before, I mean, you had a previous caseworker for Children's Services indicating that the agency would have no problems with Hayes' current home, and the agency would likely approve the current home for custodial care for all three of the children, DC and DG. We had the issue of the child care, whether Ms. Hayes could provide adequate child care. That was a concern, but then, as was mentioned earlier, case was reopened and my client addressed that with the noting that she has a flexible schedule in her work.
What was it? I'm sorry, was it reopened before the magistrate or before the juvenile court judge?
If I remember right, it was for the magistrate.
Okay.
Mr. Capsule can correct me if I'm wrong on that, but if I remember right, it was in front of the magistrate that information was provided. So that was all reopened because I know there was the concerns about that financial aspect. And it was mentioned too that she had these benefits, the flexible spending accounts. She had the flexibility in her schedule, and she had the assistance of her, I believe her sister, that can help out as well. And I think, again, it seems like there was a downplay about the bond and the visitation that Ms. Hayes had with the two children at issue here. But again, she had a history with the family. The mother was in agreement with Ms. Hayes having custody if she was not to be given her rights, parental rights. But I think to stress that, she's providing the respite care. She mentioned she visited for holidays, and she mentioned that there was a bond there. And I think that was neglected or just not taken into proper consideration. So, in that sense, I would say there would be an abuse of discretion there too, because that evidence was misconstrued or not given proper attention that it should have been.
Well, counsel, there's evidence in the record that there was concerns about the Hayes' financial ability to be able to take care of these additional children. And in the record appears that they suggested for them to obtain a license to be foster care parents would help along with that, and they didn't do that, and the court considered that. How do you respond to that? Why wouldn't they do that to be able to help take care of the additional children?
I think that, I guess, Your Honor, to answer that question, while that may have been an avenue, I think in the end, if you look at if you look at what the court had neglected, I guess if I could say neglected to emphasize, even though that could have been a route, you know, the concerns were alleviated in the sense that, you know, she indicated she was able to testify about her financial ability. She and her husband both work. Ms. Hayes and her husband both work. Indicated that they had these benefits with the flexible spending accounts to go towards childcare. The background check, there's no indication, you know, I think they had a previous one, they just didn't get an updated one. So there's no indication that that would have been changed. And I don't think the court in the end really played much significant into that. It seemed to be mostly this childcare issue, but I think that was all addressed when that case was reopened and they went and provided that additional information. And I guess, I'm not sure how much time I have left, but you know, again, it just, you know, belies the fact that you have Ms. Hayes given the custody of LH. These siblings are close. Ms. Hayes testified about the interaction amongst all the siblings when they were together. And so it just seems like to be able to provide that bond with those three siblings, you know, should be factored into that best interest analysis. And I don't think that came into play either. And again, if I could just reiterate the fact that you do have this previous Children's Services caseworker indicating that the home study would have been approved. If there are no other questions, I guess I would yield the rest of my time.
All right. Thank you, counsel. All right. Counsel for JFS.
Yes, thank you, Your Honor. So I think if we break it down by the assignments of error, when we look at the first assignment of error, we're looking at whether or not the court found by clear and convincing evidence that permanent custody to JFS was in their best interests. And the court stated in its entry that, you know, JFS's initial concerns were mother's unstable housing and income, failure to meet ZH's medical needs, her having unhealthy relationships, and the pending criminal charges. And the agency presented evidence that, you know, mother had not secured stable housing. It's very important in the magistrate's entry that she had mentioned multiple times that she had not done this and had 4 evictions since the case began. And even at the extra time that the sort of court added on for rebuttal, was unable to provide a stable address to the court at that time either. So even though, you know, as Mr. Capsule pointed out, 2 years from the filing, mother still had not been able to provide any stable housing to the court. She'd been unemployed since 2017, and this that part and the stable housing part tie back into her unhealthy relationship with Mr. Burrell, which is she stated that she relies on Mr. Burrell for housing, relies on Mr. Burrell for income, and then if the children were returned to her, would maintain a relationship with Mr. Burrell. And this caused the agency enough concern that this was something that they brought up in the trial. And the court, we believe, properly weighed that evidence that she was engaged in this relationship with him and had no intention of disengaging in this relationship. And when we think back to what Mr. Capsule said about the extra time that mom had, even throughout those 2 years, she still was going to maintain a relationship with this individual. And we think that the court properly weighted that evidence in determining whether or not the children should be returned to mom's care, because although she did complete some services, she completed her diagnostic assessment, which came back with no recommendations. She did visit with the FNC. There were no concerns with the FNC visits, and she did complete parenting classes. You know, once again, it is not sort of rote completion of services that JFS is looking for when making a determination to file for permanent custody, but it's whether or not there has been an applicable lifestyle change that the parent has gone through to demonstrate that they have learned what was wrong in the beginning of the case and have taken steps to correct that. And this case had been pending for so long that mother had, almost twice as the amount of time to sort of demonstrate to JFS that not only have I done my services, but I have shown that I understand what the concerns were in the first place. So I'm not going to engage in that kind of behavior anymore. And we think that when making the determination for permanent custody, the court properly weighed that evidence. And the evidence in determining whether or not there's an abuse of discretion, was there competent, credible evidence? And we believe that the agency did present competent, credible evidence. There's multiple caseworkers that testified, the evidence that she did complete her services, but mother's own testimony and mother's own statements to the court show that she still engaged in the kind of behavior that gave the agency enough concern. So we did have some completion of the services, but with that paramour still in her life, that was the concern that JFS had. And this ties into the second assignment of error, which was what was the best interest of the children in regards to the Hayes's petition. And JFS is concerned.
Could you address what I asked earlier, which is the disconnect between allowing her custody of the eldest child and then saying she's not appropriate for the other two?
Yeah, and so the court did address that issue sort of obliquely in its entry, where it stated it does not appear viable that she'd be able to work from a computer in addition to watch active 4- and 2-year-old children. So
well, but that to me isn't wholly satisfying, because it did indicate that she had, I think, her work was part-time or flexible, I can't remember, and her husband's work was also had some flexibility in it. So I guess I'm struggling to see where is the evidentiary basis to say that Ms. Hayes had no ability to appropriately watch these kids?
Well, I think it's we're talking about one child versus 3 children. That's more children for her to watch and take care of. And if she's balancing her ability to work and take care of the children, we think, and we believe the court believed it as well, that would be overwhelming for her.
I mean, but sorry, but every single parent in this country is dealing with that right now, with kids at home and having to make do. That to me doesn't seem like an appropriate basis to say she's unsuitable to parent these children.
And the court's correct. A lot of parents are dealing with that now, but you can also note that a lot of parents are dealing with that now, and they're struggling to deal with that now. And the agency has an ability at this time to, and the court as well has the ability to not place parents in a position to fail, and not place potential custodians in a position to fail. And one child may be enough for them to take care of, but then to give them 2 extra children to take care of might put them in a position to fail, where then the agency might end up back where we started, where then we have to remove 3 children from these petitioners because it's too much for the petitioners to handle. And then there's more trauma to the children from the removal at that point. A completed home study determining that a petitioner is appropriate doesn't necessarily mean that that petitioner should or must have placement of this children. All it is a determination that, there's no safety threats, that the agency believes that these are appropriate individuals. But the agency also has to look at whether or not they're going to place these individuals in a position to fail, because it is not an uncommon occurrence that someone will receive custody of a child or children and then come back immediately and say, you know what, I'm not doing this anymore. Please take the children back. This is something the agency sees frequently. And so I think the agency doesn't necessarily have to grant or support these individuals to have custody if they think that this is a possibility that may happen in the future. That, look, if one child is one thing, but 3 child is a completely different thing. If there's concerns about the financial ability to take care of one child, those concerns to take care of 3 children will only be exacerbated. And so the agency is looking for permanency for these children, a place where these children won't have to worry about removal anymore. To run that risk, I think, would be too much for the agency to support at that time.
So I understand what you're saying. I guess my question is, what are the indicia that convince you that she would there was a decent chance that she would fail if she got all of the kids.
Rather than having a solid plan to take care of the children if they were, say, through daycare or schooling or that matter, the idea of what she would do with the children was nebulous. Would mom come over and take care of the children? Would her work schedule allow her the flexibility to take care of the children? Would her husband's work schedule allow her the flexibility?
She had some flexible spending dollars that she could use for daycare. And I guess tying back to my earlier point, I mean, a lot of parents don't have concrete plans because their schedules change, circumstances change, and today they might lean on a parent to watch the kids. Tomorrow they might send them to daycare. I mean, it seems like we're placing an awful high burden on someone as you're articulating it.
Yes, and I think the court's correct. This is a high burden, and it should be a high burden because these individuals are petitioners for custody. They are not actual parents. And if the difference between placing the children with a grandparent that you know is appropriate versus using someone to provide daycare where the only reason you have custody of these children is because of a prior court case that this individual had, that gives the agency cause for concern. We're not dealing with someone who has the children and has to make a way for them. We have the ability to control whether or not these people are set up for failure or set up for success. And, you know, that's through the court, which is we can determine whether or not we believe that it is appropriate and a good idea to place these children with these individuals rather than a natural parent who we don't have that option with. A natural parent has the duty to take care of their children. We can make the determination whether or not giving these children to these individuals is a good idea. And I think that's what the agency's position is that one child is one child, but 3 children is a whole other ball game. And because we have the ability to make the determination about whether or not they can take care of all 3 children, that's a determination that we're making, and we don't believe that that is appropriate at this time.
So, counsel, I guess I got a little confused. So, Miss Hayes, I know she considers herself to be a grandmother figure, but is she just a family friend? What does the record show on this?
I believe she's not a biological relative, but Mr. Angelmo will correct me if I'm wrong, but my reading of it is that she was not a biological relative. That, you know, I think the term they would use is a fictive relative, and that, you know, the closeness with the family is such that she's functionally as a relative, but there's no biological tie there. That's my understanding. And I read the same thing that Your Honor did, and I could have misinterpreted it as well.
Thank you.
Well, if the court has no other questions, then the agency would yield back its time.
All right. Thank you, counsel. Mr. Harden?
First, let me say that I do agree with JFS and the decision to believe that it is in the children's best interest to place them in the permanent custody of the agency. I want to start off by answering the question you just asked. The way it happened was that Ms. Hayes is the father or the mother of a potential father who was later ruled out via paternity. So she thought she was grandmother, and then it turns out she was not grandmother. And that was of DG. And the guardian supports the children being placed in permanent custody, not because of necessarily any concerns with Ms. Hayes, but because the children are bonded with their foster family, and the foster family is expressed as an intent to adopt. When Ms. Hayes as everyone is kind of acquiesced to, Ms. Hayes has been involved in every court proceeding and did provide some respite. When she filed a custody petition, what the guardian and the JFS did was went out and had a conversation with her, went and did an investigation as would be expected, and she expressed concerns about childcare. Childcare is a reasonable part of life. And so what we, and I say we because I was there and part of the meeting, did was lay out a 12 to 14 class, or over 12 to 14 weekends, a parent or a care provider can become a foster parent and receive a stipend for taking care of those children, thinking that if she was going to be in an appropriate placement, and this was in 2018, that we would provide this avenue for her to become a placement provider, and she didn't do anything about it. And during that time, from June 2017 till now, DC and DG have both remained in the same foster home, have continued to bond. Now,
So did anyone ask her why she didn't follow up with that?
several times, and her response was, I don't have time to. It's just not what I want to do right now. While she did talk about, she repeatedly verbally requested placement. At time, whenever the time for her statement was frequently, and it's in the record, that she would request placement if no one else was available, or if she was able to obtain childcare, or if the finances were right. And again, feeling like she'd been involved in the children's lives and feeling like this could be a possible placement, we provided that avenue, and she didn't take us up on it. And that whole time, the children remained in foster care, remained with people who were taking us up on it. You know, from June 2017 till now, DC and DG have remained exactly where they are. They are 5 and 3, and they're bonded in a home that they know and where they're loved. Ms. Hayes did provide limited respite, but never really built that bond, and when presented with the opportunity for becoming placement, she didn't take it.
Anything further? Any questions? All right. Thank you, counsel.
Thank you.
Mr. Capsule, you still have some rebuttal time, sir, if you'd like to utilize that.
Yeah, just briefly, thank you, Your Honor. Just with regards to the Hayes relationship, from the trial of it, there many things that were said were true, but actually Ms. Hayes, and this is in the record too, not just me saying this, that she was a friend of my client's mother. They grew up in English Woods. So she had been involved with them. Actually, they knew Mr. Burrell's mother too, from that neighborhood. So but what Mr. Hardin said is correct, because one of the children is named after her son. But I guess with testing, it found that he wasn't. But even more remarkably, that demonstrates Ms. Hayes' commitment to these children, because she had no other reason to be involved other than her affinity for these children. When we talk about whether or not she established a bond, and I think this is what also, again, is different from that Schaefer case, all of the children lived with her at one point. Then they lived with her daughter, who was a foster parent, and which she had irregular interaction with, like daily. You don't even have that for most people through visitation. And the fact that these children, where I think also an abuse of discretion comes in here, because I don't know that you can look at this result and say that these two children have to suffer because they were the ones that were in foster care. But you look at LaRue, the one that's not part of this case. When he was in that same foster home, he was put into a psych ward by this foster parent. He was put on medication. We had hearings over that. Then he goes to Miss Hayes' home. He's off the medication. He hasn't been to a psych ward. He's receiving really good care. So and I know Miss Hayes had some issues with that during the trial with the foster parent when she was testifying about that. So why would these two children have to be kept away from their other siblings for the rest of their lives, their parents, this support group that they had, that they lived with? Why would that have to be their best interest? You can't say that that really is their best interest, to have all of that happen to them simply because they were in a foster home for that long and were not given up by that foster parent. I think it is proper rebuttal, because we're talking about best interest. There is one other child that's still floating around out there, which is ZH. And I think that in just rebutting that it's in their best interest, and the court had this evidence that ZH also lived with mom and Miss Hayes for a long part of his life. I know there's some discussion, or even in Mr. Besniano's brief, terming that he had extreme issues, but actually the evidence was that he didn't really. He was just in a nursing home because the agency couldn't find any home-like placements for that child, who was also a sibling of these two children that were permanently committed. I know that Miss Hayes didn't ask for a ZH because at the time being in a nursing home, but nonetheless, I don't know why. Also, we're not even talking about that child. There's no plan for that child, which is the point of permanent custody. At least the two of them have, between foster parent and Ms. Hayes, but with regards to ZH, it seems unfortunate for that child to be permanently committed when at least with regards to mother, that you can get housing and can take care of that child. But overall, whether or not the foster parents intend to adopt is sort of irrelevant when you're talking about what the real issues were. If everybody was on board with Ms. Hayes and her husband being the custodians, the only thing is they didn't know about the money issue, not even the plans, just the money issue. But then Ms. Hayes cleared that up. So I think it's not enough evidence and also an abuse of discretion to deny that petition and essentially keep these two children just cut off from the rest of their family. Thank you.
Thank you, Councilman. Mr. Anzimo, anything else, sir?
Just briefly, I think that the appellees seem to be downplaying the relationship and the bond between Ms. Hayes and these children. As was pointed out, they did live together as a familial household at one point in the past. They did have visitation. There was the respite care, but there's evidence that they saw each other during holidays as well. And the evidence shows that they all got along with each other. And even though there may not be a biological connection, she considered herself as a grandmother, and they considered her as a grandmotherly figure as well. And I think the proper course of action is to allow these three children to be in the same household and prosper, just as Ms. Hayes demonstrated she did for LaRue. Thank you, Your Honors.
All right. Thank you all for your arguments this morning. The case is now submitted. Obviously, there's a large record of cases. It's difficult, but we will thoroughly go through everything and issue a timely decision. So thank you for your arguments this morning.
Thank you, Your Honor. Thank you, Counsel.
Thank you.
Thank you.
Thank you.